if the judge is asking you a question like, how long can you sit before you do? Oh, 10 minutes, Your Honor. And you keep doing that over and over. You're not letting the judge complete the question or your lawyer. So you don't want to interrupt. The other thing about interrupting, and if you do it too much, some judges will think you're being rude. I've seen judges call claimants out on it in the middle of a hearing. Excuse me, you're being extremely rude. You're cutting me off. And that's the nice way they say it. I've seen them say it a little bit meaner. So you just don't want to kind of keep interrupting your lawyer or the judge in the hearing. And again, just don't be distracted if you're or if you're doing a Zoom or MS Teams hearing, you can make good eye contact that way with whoever you're talking to or whoever's asking questions. So rule number 1, listen to the question. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. Good morning.
Good morning.
Well, thank you for joining me, John. For those of our audience who don't know who you are, your name is John Ropp. You've been working for the firm in the capacity of being the manager of our hearings and that team of folks that we bring around our clients that are about to go to hearing. And you and I I think it's been about a year ago, shot a video, a little bit about background just about who you are, and then your kind of educational experience, work experience. And then, you'll probably be off to law school here sometime in the next 12 months, give or take. So that's exciting as well. So I will link that video for you in our description if folks want to learn more about you. So welcome.
Thank you. Yeah, absolutely. Happy to be here. That's
so
wild that it's been that long since our first video.
Yeah. Time flies by fast. I think today, and the reason I wanted to have you in is you and I shot a video, again, probably about a year ago, about kind of the tips to prepare for a hearing. What we really focused on back then was sort of the file aspect, the medical records. Maybe if you could just give us a quick summary of what you remember of just sort of, or maybe some quick tips, even updated since a year ago, things that claimants should do just to, even before they walk in the courtroom, and let's maybe say 3 months before their hearing date.
Right. So before the hearing, you've got a lot of time to get things in order and collect supportive evidence. I think the most important thing that you can do is find a doctor who truly believes that you're disabled, and see them consistently. And then that supportive evidence will almost kind of form itself if you develop that relationship with a medical provider. I know we discussed this in our last video. We have questionnaires that our firm has created for medical providers. So having a supportive provider who can fill out one of those questionnaires makes a huge difference. Getting consistent treatment from your doctors makes a huge difference. And over the last year, I think the thing that I've found is maybe the most important is being very honest with your doctors and telling them every time you see them how you're doing. I think people have a tendency to downplay how much they're struggling or how much pain they're in, whatever their condition is. And that's really what the judge is going to look at during the hearing is day to day, how much are they struggling? Is their pain consistently a problem every time they go to the doctor? So developing the file, happens every time you go to the doctor, because what you tell them is going to end up in the medical records.
Right. And then another big thing that I think that stood out to me in our conversation, and something, a lot of people, if they're not represented, don't realize, is that Social Security has stopped ordering their medical records, and they have this file. So a lot of times folks will show up to a hearing, and because the average wait time, for a hearing, it's different in every office, but is typically at least a year. So there's a year's worth of medical evidence missing. And if I remember correctly, and we kind of advised in that video, like, go get your file, look at it, review it, and see what's missing. And a big part of what your team does is order medical records.
Right.
And then follow up on those, to make sure they get in time. And then, and there's an actual, as a quick recap, there's a 5-day rule, which is what?
The 5-day rule is essentially a requirement for informing the judge about evidence or submitting it. So 5 business days prior to your hearing, you have to either submit all medical evidence that you have that's not currently in the file, or inform the judge in the form of a letter that there is additional evidence that you're waiting on and intend to submit. Typically, that's always just going to be 1 week before the date of the hearing, unless there's a federal holiday in between those
Right.
7 days. But yeah, 5 business days before the hearing. Basically, you got to tell the judge everything that you're planning to get into the file.
Yeah. And so that's a kind of a recap on some just prepping your file. I think, we have, a mock hearing video that I would encourage people that are not represented to go watch. It's on our YouTube channel. It's also on our website, but you'll find it here on our YouTube channel. It's a mock hearing that's done by one of our attorneys who does hearings for us. His name's Dan Hyatt, who actually was a former Social Security law judge, and so he's now representing claimants. I was the client, or pretended to be the client, and then we had Jack Cahill, who played the role of the attorney. And in that, it really walks through what a typical outline of a hearing is. It from kind of the judge and the attorney discussing about what's going on with the evidence and the medical records, down to an examination and cross-examination of the vocational expert. I'd say in 90% of the 9 out of 10 hearings, there will be a vocational expert in the hearing. So it's really important to watch that. I always encourage our clients to watch it, because it literally will walk them through what a typical hearing looks like. Now, every hearing is a little different. Some hearings go 5 minutes, some hearings go 2 hours. So we're just trying to give you a sense of what the average hearing looks like. But in today's podcast, because one of the things we send out, as you know, is something called the pre-hearing conference packet. And part of what you and your team do is kind of walk them through generally, here's what you have to go through. And what I'd like to do is talk to the audience today that is not necessarily our client, and walk them through the pre-hearing conference packet. And it's kind of in-depth information that we try to give our clients. And one of the first things, and I wanted to chat with you, and I have other videos about this too, so we'll just kind of go through this quickly, and I don't want to deep dive too much into it. But one of the first things we talk about is kind of what type of hearings can you have in that pre-hearing conference packet, because there's literally 3 types, 4 types, but I don't really count the 4th because it seems silly to do the 4th one. But there's in-person hearing, where you go to your local Social Security hearings office, not your local Social Security office, your local Social Security hearing office. And that's a big difference, because in Oregon, for example, there's only 2 hearing offices. So in Washington State, there's only 3, right? And in Idaho, there's only 1. There are multiple local Social Security offices all over Oregon, especially if you get into the Portland area. I mean, there's half a dozen just in our area, if not more. So there's a distinction there. The second one is a phone hearing, where you can do it from home, and just be on the phone. And the third one is an MS Teams hearing, which is like Zoom. And the fourth one is at what they call a video teleconference hearing, which is basically you still have to drive all the way to the hearing office. You're by the equivalent of what we know as Zoom, but you're with a judge that's outside of your local Social Security hearing office. Which one do you, and as a firm, and I already, of course I'm asking you questions, I already know the answer, but which one do we suggest to our clients to do?
So we always recommend phone hearings. We request phone hearings for every client unless they specifically want something else. And even in those instances, we usually discuss with them. There are a handful of reasons that phone hearings are preferable. And I can go into those if you'd like. But
just quickly, like what's the top 1 or 2 reasons?
I think the number one reason is, and I see this happen when we have video or in-person hearings, is the judge will make an assessment of your ability to work and function based on how you look. Some people look like they're a lot less disabled than they actually are, especially with mental health issues, or if they're having a good day. That isn't perceived as much over the phone, and you're able to really keep things limited to your testimony, which I think is a valuable tool. That's why we definitely recommend phone hearings for everyone.
That's 100% correct. I mean, that's one of many reasons. It's the top reason in my book. I think, like you said, judges end up becoming witnesses to their own hearings, in a sense that, they're observing you from the minute you walk into that door. How is this person ambulating? Meaning, how do they move? Do they look discomforted when they're sitting? One of the questions that comes in the hearing is, how long can you sit before you need to stand up? And if you say like, oh, I can only sit for 5 minutes, the judge will look at the clock and either say verbally to you or think in their head, well, gosh, you've been sitting there for 45 minutes and you've yet to stand. So when you're by phone, they cannot make those observations. In fact, they're supposed to do their job, which is to observe, to read and go through the medical records and then to take your testimony verbally from that point. They're not doctors. And sometimes what they'll do is pretend to be doctors, I guess, in their head based off of how you look that day. So that's great. That's great. The thing that I really wanted to cover today, other than just sort of the phones and the 5-day rule, is just really talk about how a claimant should prepare for their testimony. And I think the mock hearing gives a good example of the types of questions that will come your way. But it's too hard to predict, because the judge is asking you questions or asking the claimant questions. So it becomes very, very difficult to write a script or predict a script because every judge is a little different and every case is a little different. Right. Now, I can predict generally a big bulk of the questions that they're likely to ask, right? Because I've been involved at this point in thousands of hearings. Literally in the last 25 years or 24 years, I've been in thousands of hearings. And so a lot of the hearings follow the same format. But, I hate to tell people to rely on this and then it goes a different way. So I'm kind of throwing in all these caveats before we deep dive. The thing that I do, though, and I've done, I think, 26 jury trials. I've done, I don't know, probably a half a dozen to a dozen bench trials, and then again, tons of hearings, thousands of hearings. I've done a half a dozen arbitrations. So I love going to court. I love it. So in many ways, when you're preparing your witness, whether it's a criminal trial or a Social Security hearing or a civil hearing or a civil matter, a lot of times I'll use the same rules in preparing witnesses. And I wanted to have this discussion with you as you go off to law school soon, that maybe you can pass this sage wisdom along, because I didn't create this. Someone taught it to me. My mentor, a lawyer, taught it to me, and I love teaching it to other people. So instead of saying, hey, look, to the clients, here's the basic script of what's going to happen, what we do is, or what I like to do is teach them how to answer questions in court. What are the fundamental basics of some rules that they can follow in their head on how to answer these questions? So rule number one, okay, and I talked about this in last week's podcast, but when people were testifying hearing, but I wanted to go into it in more depth. Rule number one is listen to the question and be an active listener. So if you're in person, you want to make good eye contact with the person you're talking to. Okay. Obviously, if you're by phone, you just want to be paying attention to what's going on with the conversation on the phone. You don't want to be looking at your screen or reading, or reading your local news or having the TV on in the background or even having someone else in the room talking to you. The other part of being a really good listener is do not interrupt, okay? If the judge is asking you a question like, how long can you sit before you go, 10 minutes, Your Honor, and you keep doing that over and over, you're not letting the judge complete the question or your lawyer, so you don't want to interrupt. The other thing about interrupting, and if you do it too much, some judges will think you're being rude. I've seen judges call claimants out on it in the middle of a hearing. Excuse me, you're being extremely rude. You're cutting me off. And that's the nice way they say it. I've seen them say it a little bit meaner. So you just don't want to kind of keep interrupting your lawyer or the judge in the hearing. Okay? So, and again, just don't be distracted if you're or if you're doing a Zoom or MS Teams hearing, you can make good eye contact that way with whoever you're talking to or whoever's asking questions. So rule number one, listen to the question. Rule number two, make sure you understand the question. If for any reason you don't understand the question,